All rise. Supreme Court of Florida is now in session. Please be seated.
Good afternoon. Welcome to the Florida Supreme Court and the 2017 final round of the Florida High School Moot Court competition. We are pleased to have teams from throughout Florida today, and we welcome the students as well as their teachers, coaches, parents, and families. We are encouraged to see such interest in learning about the state courts and the appellate process. I would like to thank the judges in our district courts of appeal for their participation throughout the state. The high school moot court competition is comprised of two phases. The first phase is the brief writing component. Then select teams are invited to participate in oral arguments in one of the 5 district courts of appeal in Florida. The highest ranked teams receive invitations to participate in the Tallahassee program. Yesterday, all teams presented oral arguments in preliminary rounds at the 1st District Court of Appeal and the Florida State University College of Law. Today we have the top 2 teams as recommended by those judges to present oral arguments before this court. Following oral arguments today, we will return to conference to discuss the outcome for a few minutes. We will not announce our decision, but we will return to the bench for some general comments and official photos with each individual team. So, our case today is State of Florida versus Hunter Wilson. Are both teams ready to go? Okay, you may proceed.
Good afternoon, Mr. Chief Justice, honorable justices, may it please the court. My name is Connor Malusnik, my co-counsel is Jasmine De Valle, and today we represent the petitioner in this case, the state of Florida. I will argue the first issue of whether the defendant had a reasonable expectation of privacy, and my partner will argue whether the use of the drone in this case violates the Florida statute 934.50. At this time, we would like to request to reserve 2 minutes for rebuttal. There was no reasonable expectation of privacy in this case for 2 reasons. First, the defendant did not satisfy the subjective and objective tests of privacy set about in Katz v. US. And second, the scene in this case was observed while the drone was in the public airspace. For the defendant to exhibit a reasonable expectation of privacy under Katz, they must meet both a subjective and objective test.
Can we just go to this area was the curtilage of the house?
That is correct, Your Honor.
Does it matter for the purpose of the state's argument that this was a fraternity house versus somebody's house?
Well, Justice Pariente, that determination is inconsequential. We concede that the DOD house was a curtilage area,
okay,
and we.
So how many was there fence around there?
Justice Pariente, the record notes, I believe on page 24, that there was a fence that surrounded the DOD backyard. And there was hedges as well, correct?
Don't we have a case from many years ago that says that really that kind of a fenced-in curtilage is, there is a reasonable expectation of privacy? Well, the case, are you familiar with the case?
Yes, Your Honor, and you are correct in saying that a fence without any other circumstances does normally provide an expectation of privacy in the subjective sense. However, we would like to distinguish the expectation of privacy from one going into the property and the expectation of privacy from one being able to view into the property. Even if there is a fence in the area, if persons are still able to view into it, especially if the person in question is aware of that, then that suggests a lack of expectation of privacy.
You would want us to have as a rule, a holding, a constitutional holding, that because we have these drones now available to law enforcement that can hover just right close to the airspace, that there should be no more expectation of privacy in somebody's backyard?
No, Justice Pariente. We only argue that when an area is normally observable, and especially when the person in question is aware of those viewings, that degrades the expectation of privacy.
Are you saying that the defendant knew there was a drone hovering over the backyard?
Justice Pariente, we do not argue that. Instead, we contend that the defendant was aware of the viewings that took place from the hill in this case.
Well, let me ask you this. The hedge was 8 feet tall, and the fence was 4 feet tall. What part of it was then visible to the average person walking by? Because that's the real issue here, isn't it? It's whether or not it was viewable from an ordinary viewpoint.
Justice Quince, the area that allowed for the observation was the hill in this case, and the record discusses this beginning on page 24, line. It states that the elevated hill next to the home allows for a clear view of the backyard where the activities were observed by the drone.
Wasn't that hill not accessible to the general public?
Well, Justice Quince, the record does note on page 24, line 13, that it was not freely accessible to the public. However, it does not state that the hillgoers were trespassers or that it was an illegal vantage point. Its failure to do this, we would argue, suggests that perhaps the hill was partially blocked by foliage, but it does not go as far to say that it was an illegal vantage point. And for that reason, we would argue that the hillgoers were there legally.
It seems like State v. Ricard is a easier case for the state, but the state lost. And so I'm trying to understand how do you distinguish that case from this court from 1982?
Justice Pariente, we would distinguish the case of State v. Rickard in both the subjective and objective sense. In Rickard, fences and partitions and sheds were erected to block out viewings of the defendant in that case's his backyard. And the defendant in that case was not aware that observations could take place. And in fact, observations prior to intervention by law enforcement did not take place. So in both the subjective and objective test,
where in the record does it say that this defendant knew that people were, prying, looking into this private backyard?
The record suggests that on page 24, line 14, Your Honor, when it states that it was known that students ventured onto the land. This suggestion by the record, we would argue, suggests that the defendant was aware of these observations, and the fact that nothing was done about these observations erodes their subjective expectation of privacy.
Where does the anonymous tip fall into all of this? Is that going to be your
Correct, Your Honor.
counsel that's going to address that?
Yes.
Okay.
And moving into the objective consideration of privacy, under Katz, society must recognize expectations of privacy as reasonable for them to be legitimate. And because the Hill not only provided for viewing access to the backyard, and the defendant was aware of this, but because public viewings, in fact, did take place, this recognition plainly did not exist. Furthermore, due to
Why are we talking about the elevations of land as being the critical factor when, in truth and in fact, this was an airborne surveillance that picked up the evidence?
Justice Lewis, we consider the observations from the Hill because it is what established the lack of an expectation of privacy on behalf of the respondent. Once there is...
That's irrelevant. I mean, you know if you're in your backyard that you're always subject to views from the air. So what does a hill next door have to do with open skies?
Justice Lewis, we would agree that constitutionally the views from the drone in the air are the most relevant consideration. However, it should be noted that Florida goes a step further than the normal Constitution by providing in the statute 934.50 that one is presumed to have an expectation of privacy when they are not observable from persons at ground level. So it is important to establish that they were observable from ground level, and we argue that is established through the Hill.
Statute that establishes the constitutional parameters in this case?
No, Justice Lewis. It extends constitutional
That's what I'm saying,
protections.
statute, you have a statute that will define for us what the Constitution allows or does not allow.
Well, Justice Lewis, all persons are protected under the Constitution, and the Florida statute in this case extends privacy protections to another degree. However, we argue that we meet those extended expectations because the defendant in this case was observable at ground level. And furthermore, due to the nature...
Is it really ground level if you're talking about standing on a hill? I mean, it would seem to me that ground level would be where the house is located as opposed to some vantage point above the house.
Justice Quince, you're correct in saying that the hill was an elevated area, but it is still a part of the ground. It is not a protrusion out of the ground like a tree or a building. And for this court to rule otherwise would require it to set some sort of standard for what is ground level
So
as opposed to the natural ground.
We would be saying that if you live in a hilly or mountainous area, and if you can stand on the mountain and see, then you're at ground level.
That is correct, Your Honor. For these reasons above, the defendant lacked a subjective or objective expectation of privacy and therefore lacked a reasonable expectation of privacy under the Fourth Amendment. For those reasons, we would ask this court to reverse the decision of the 6th District Court of Appeal. Thank you.
Good afternoon, Chief Justice Labarga, honorable justices, and may it please the court. My name is Jasmine Del Valle, and today I'll be presenting the second issue in this case, and that is whether Florida Statute 934.50, addressing searches and seizures using a drone, was violated through the request of Sergeant Johnson to obtain footage based on an anonymous tip that he had received from dispatch.
Is the same standard of anonymous tip for reasonable suspicion that's applicable to general Fourth Amendment law as represented in JL and other precedent, the same standard as for the statute reasonable suspicion?
You are correct, Justice Periente. We would use the standard of reasonable suspicion that has been established through case precedent such as Florida v. JL, Alabama v. White, etc. The Fourth Amendment application would constitute as a search in which we would have to provide probable cause for a warrant, in which we would differentiate that standard as opposed to this case where it only asks for reasonable suspicion, which it is known that reasonable suspicion is a lesser standard compared to probable cause.
Obviously, as you said, it's an anonymous tip, and I'm having trouble to understand how there was any independent corroboration based on the fact that this officer had been part of this school how many years ago?
Well, according to the record, it points towards that it was about 2 decades ago.
20 years ago.
Exactly.
So you're not really arguing that him maybe knowing what went on or didn't go on 20 years ago could establish reasonable suspicion for the present time?
We can see, Justice Periente, how his experience 2 decades ago may not be applicable in this case. However, his experience being that it is a fraternity, which is basically an institution that has established tradition throughout the years, also combined with his current knowledge being a university police officer, that knowledge combined allows an establishment of a basis of knowledge.
So are you saying then, even without the anonymous tip, because hazing apparently is pervasive at universities and at frat houses, that would establish that police could use drones all over all the backyards of all the fraternities and sororities, I guess, in the state of Florida? Probably send chills up a lot of these FSU students, I would say.
Right. Well, Justice Periente, in regards to different fraternities and sororities in your hypothetical, it would not be able to, his knowledge, his specific knowledge of the DOD fraternity would not be able to apply to any other fraternity or sorority.
But you just said 20 years ago is really irrelevant. Maybe they were Animal House 20 years ago, and today they are like the honors fraternity on campus. So that would be really not, I mean, again, if we take out his 20-year-old knowledge, what present knowledge did he have about the activities at this fraternity?
Well, Justice Periente, in determining whether his knowledge combined with the anonymous tip would be able to satisfy the reasonable suspicion exception provided in the statute, I would look towards the progression that the court has seen in establishing reasonable suspicion using information and knowledge of an officer, such as in Terry v. Ohio, where it used Sergeant McFarland's experience and firsthand observation to establish reasonable suspicion.
The question was, if you take that knowledge away,
right,
and you just have the anonymous tip, what did this officer do to corroborate any of the information that was given in an anonymous tip? You agree that that when you're in an anonymous tip situation, there should be corroboration of, is that a factor?
Justice Quince, we do concede that there was no independent police work conducted at the time. However, we do consider the situation.
Okay, we're talking about, but we're taking away the officer's knowledge, okay? Right. So we end up with the anonymous tip. That alone, are you saying that alone is what gave them the reasonable suspicion to use the drone?
Justice Quince, we are not contending that the anonymous tip alone establishes reasonable suspicion, because that would go against case precedent.
So what do you have other than the officer's prior knowledge of this fraternity, whatever group it was?
Well,
what else do you have?
Justice Quince, we can't, as the petitioner, we can't just, based on case precedent set back forth with Terry v. Ohio, Adams v. Williams, Alabama v. White, etc., and Navarrete v. California recently, we can't just ignore a police officer's experience.
But I think the problem is this. The prior knowledge in a personal capacity, you're saying that's 20 years ago. There's no, in Terry, there was a police officer watching in the middle of the night a ultimate defendant what appeared to be casing the joint. There is nothing in this record that shows that the sergeant had that kind of knowledge. Can you refresh my recollection? What's in the record that explains what his professional capacity was that made him realize that this anonymous tip was reliable?
Right. Justice Periante, on page 25 of the record, I believe it is at the end of paragraph 5, it mentions his personal and professional experience. So not only combining his experience with the DOD.
But you can't just say it, and it's not, you're stuck with the record, right? When we're here on appeal,
right,
you can't put additional facts in. So if the trial lawyers didn't give more information, you're stuck with that record.
You are correct, Justice Periante, but in being able to use the record, it establishes that Sergeant Johnson is able to use his experience, his current experience to...
besides his experience,
yes,
is the fact that a death had taken place at the house, that they had actually been there before, are those factors that you take into consideration in determining whether or not there was a reasonable suspicion here?
Well, Justice Quince, the record doesn't provide any sort of information that says that he had been to the DOD house before. However,
I thought after the young lady's death,
yes,
that they had actually searched the place, yes, and but found nothing. That didn't take place in this record?
On the record, Justice Quince, it says that he examined the house after arriving, and
he
then
ordered the drone. He ordered the drone unit to go before he even got to the house.
That is correct, Justice Periante.
So if it had been otherwise, if he had gotten there and saw something suspicious, and then contacted the drone unit, you'd have a different case. But that's not what happened.
That is not what happened, Justice Periante, because in your hypothetical, there would be no need for a drone. The use for the drone was to look at the exact location that was provided in the tip, look for the exact participants that were named in the tip, look for the exact activities that were provided in the tip. All the specificity provided was what the drone was looking for because it provided the specific location where the drone could go towards.
So
and
you're really saying the drone, even though the statute says otherwise, supplies the basis for a reasonable police investigation, and that would mean that every drone unit would be appropriate because you get a tip and now you use the drone to, instead of the police eyes, to surveil. And that's not what the statute allows.
No, Justice Periente, the statute only allows the drone to be used in a circumstance where reasonable suspicion of imminent danger occurs. And so that's exactly what the tip provided in this case. It provided information, an assertion specifically that the participants of these fraternity activities could possibly be harmed if the activities were to continue. And
what
so,
were the activities the students said were taking place?
Well, based on the record, it says that there were certain activities such as being forced to eat mystery food and being forced to have physical activity, and then it was also observed through the footage that the specific activities that were being alluded to in the tip were confirmed.
Again, you cannot use what they saw at the drone strike to, I mean, the drone strike, please, the drone surveillance to justify that it was reasonable to do in the first place.
Justice Periente, we're not using the drone footage to corroborate the information. We used his information, his personal knowledge, to determine the reliability of the tip, which would satisfy the totality of the circumstances requirement established in Alabama v. White for the veracity, reliability, and basis of knowledge. Considering the situation as a sense of urgency, we would say that he didn't have enough time to independently corroborate. Thus, the drone served as a specific indication as to what actions needed to be taken, such as 911 and ambulance, etc. So we would argue that concerning anonymous tips and reasonable suspicion, we would argue that in Everett v. California, Justice Thomas specifically said that in situations of imminent danger, situations where there is a sense of urgency, that an anonymous tip where a police officer would be able to determine the reliability of the tip, that he could go forth with the investigation. And we would use that case to establish reasonable suspicion under Exception 4C to dispatch the drone, and under Section 6 of the statute, be able to use this evidence afterwards, after he took the necessary precautions. And so it is for the aforementioned reasons we would ask this court to reverse the 6th District Court of Appeals decision and affirm the trial court's decision. Thank you.
Good afternoon, Chief Justice Labarga and Honorable Justices. May it please the Court. My name is Ariel Lorenz, my co-counsel is Mia Venezia, and together we represent Mr. Hunter Wilson, the respondent. Of the two issues, I will address the first, of whether or not Respondent Hunter Wilson had a reasonable expectation of privacy pursuant to the United States and Florida Constitution. While my co-counsel will address the second issue, of whether or not Sergeant Johnson's use of drone surveillance was in violation of Section 934.50 of the Florida statutes. There are three reasons why we are asking this court to affirm the decision of the 6th District Court of Appeal, as Respondent had a justifiable expectation of privacy. First, the backyard of the DoD house is a curtilage area meeting the standards as established in California v. Serralo. Second, the backyard of the DoD house passes the two-pronged test for a justifiable expectation of privacy established in Katz v. United States. And third, the drone usage included a zoom feature violating a reasonable expectation of privacy as established in Kylo v. United States. In Article 1, Section 12 of the Florida Constitution, it protects the right of the people against unreasonable search and seizures in their houses, papers, and effects. California v. Serralo establishes a curtilage area as one that is both physically and psychologically connected to the home and is considered to be an extension of the home.
Well, we accept that definition that it is a curtilage, but your opponent argues that because it could be seen that there was no real expectation of privacy because anyone, I guess, on the Hill could actually see what was going on in that curtilage area. How do you respond to that?
Yes, Justice Quince. While opposing counsel attempted to assert that Respondent Hunter Wilson was aware that the visual surveillance could be taking place from the hill, we would argue today that it does not state anywhere in the record that Respondent Hunter Wilson was aware that people could gain a view from that hill. And additionally, the record states on page 25 that the view of the backyard from the elevated hill, that hill was not freely accessible to the public. Therefore, we would submit today that the hill did not serve as a legal vantage point for the public to be able to observe the events occurring in the backyard.
How about the upward view without regard to the topography of the land? The aerial view.
Well, the Florida statute 934.50 establishes that a reasonable expectation of privacy is granted when there is no clear view from ground level and despite a view from above in the aerial view.
So is that how you distinguish the California versus Ciriallo case where they sent officers in a private airplane to fly over the house? I mean, is it because there's a statute, or could you independently of the statute find a reasonable expectation of privacy that drones are invading that privacy? How are we going to treat drones? So, or do we just have to go to the statute to make that decision?
Yes, Justice Periente, we would additionally distinguish California v. Serrallo from today's case, as the naked eye was used in California v. Serrallo from the plane to observe, and additionally the photographs were taken. In today's case, a drone was used, and not only was the drone footage taken, but the zoom feature of a drone was used to identify Hunter Wilson's face, and that was later used by Sergeant Johnson to arrest him because it was used to identify him. So we would distinguish that additionally.
Would you agree, because under our state constitution, we must interpret the Fourth Amendment consistent with the United States Constitution. So does the statute doesn't trump whatever would be unconstitutional or constitutional under the Fourth Amendment, correct?
Yes, we agree that the statute is not trumping anything in the Fourth Amendment in the Constitution. It is agreeing with what's stated in the Fourth Amendment, but therefore just providing extra rights to the Florida citizens of Florida. Katz v. United States establishes a two-pronged test to determine if a reasonable expectation of privacy is present. The subjective test is used to see if that individual has exhibited an actual expectation of privacy. The record states on page 25, line 8, that an 8-foot-tall hedge along with a 4-foot-tall fence surrounded the DOD backyard, serving as a means for Respondent Hunter Wilson to hinder the outside world from viewing the private events occurring within the backyard, as not only was there a fence surrounding it, but there was a hedge. The objective test is also used to determine if society is prepared to recognize this expectation of privacy and consider it to be valid. In proving this, we look towards State v. Rickard, where the Supreme Court of Florida stated that a right to privacy in a person's backyard is deemed reasonable to society. Although the record describes an elevated hill with a view of the backyard, as Justice Quince said to opposing counsel, this was not freely accessible. Oliver v. United States establishes open fields to be areas that are accessible to the public and police in ways that homes, offices are not, in commercial structures would not be accessible. These areas are deemed acceptable for a police officer to conduct a search. In contrast, because that hill was not freely accessible, therefore we would argue today that the hill would not serve as a legal vantage point for the police to conduct a search or for anyone to be upon that hill and observe the events occurring within the backyard. The record is also silent on whether or not Respondent Hunter Wilson was aware that that hill had a view of the backyard. And as State v. Rickard states, the reasonable expectation of privacy is diminished when the defendant who has the expectation of privacy is aware that people are viewing anything occurring where they have that expectation of privacy.
Your opponent's argument suggested that the record was different, that your client did know that people accessed the undeveloped land. and you're arguing that that's just not true, but if assuming that the record does say that your client knew that people did go onto that undeveloped land and therefore could see into the backyard, would you concede that there would be no reasonable expectation of privacy under those circumstances?
Yes, Justice Lawson. If the record did state that Defendant Hunter Wilson was aware that these people were up there and being able to observe the backyard, we would concede that that would diminish that reasonable expectation of privacy. But on page 25 of the record, it simply states that it was known to some that the view, that the elevated hill had a view.
But, so even if you could observe from the hill, is that the same as observing it at ground level? I mean, I'm kind of stuck on that issue. When your opponent talked about it, it seems to me that what it requires is that you be able to view it from an ordinary viewpoint, and on a hill is not necessarily, in my estimation, an ordinary viewpoint.
We would concede that the elevated hill would still be a part of ground level, as someone could be able to stand on it and it would be the ground level. But we would also distinguish the fact that it was not freely accessible to the public, so it would not serve as a legal vantage point.
Is this the trial court, though, found differently on this issue? And isn't the question of whether he had a subjective expectation of privacy based on whatever facts were developed in the record, is that a fact question or a law question? In other words, do we defer at all to the trial court's findings on this? What does the record say about what the trial court found?
The record states that the trial court found that the placement of the hedges and the fence served as a subjective expectation of privacy.
So that's actually, that actually fosters your view about that the facts are supported, as the trial court found, by the record.
Yes, we would agree that the facts support the fact that there is a subjective expectation.
Well, that's a good thing for you, right?
Yes, Your Honor.
Is that a fact, or is that a conclusion of the law?
We would state that it would be a conclusion, as that the fence and the hedges served as that subjective expectation of privacy and would meet that, as it served as a means for Respondent Hunter Wilson to prevent the outside from viewing what was occurring in the backyard.
You seem to be arguing that the expectation of privacy will be determined by the clarity or the detail of the view as opposed to the view, because you keep mentioning the zoom lens. Is there a case that talks about one's expectation of privacy from the air? In terms of, because I would assume that from the air you can see what they're doing. You may not be able to see fingerprints, but you can observe from the air, can you not? Whatever's going on in that backyard, and isn't that the determinant factor for the expectation?
Chief Justice Labarga, I see that my time has expired. May I briefly answer Justice Lewis's question and conclude? Well, we would align the fact that it was observable from the air. It was observed with the drone taking the video footage, but the video footage was not only used to observe the events occurring. There was a zoom feature, which would be an enhancement on the naked eye to identify Hunter Wilson, not only just to observe anything going on. The naked eye would not serve as a means to zoom in on someone's face and be able to identify someone. Someone's eye could not do that. And therefore, we would align that to, as in Kylo v. United States, how the thermal imaging device was deemed to be an enhancement on the natural senses. We would align that as a trial court aligned, as a trial court aligned the use of thermal imaging device to the use of the zoom feature to identify Defendant Hunter Wilson's face. It is for those aforementioned reasons that we would ask this court to affirm the decision of the 6th District Court of Appeal in favor of Respondent.
Chief Justice Labarga, honorable justices, may it please the court. My name is Mia Venezia, on behalf of the respondent, Mr. Wilson. And in today's case, I will be addressing the second issue, whether or not Sergeant Johnson's request for drone footage was in violation of Florida Statute 934.50. There are 3 reasons why this court should uphold the decision of the 6th District Court of Appeal. Firstly, Sergeant Johnson acted in violation of Florida Statute 934.50 because he used a drone to obtain evidence or other information.
Did he know at the time he ordered the drone unit activated that somebody had died in the back or was unresponsive in the backyard?
No, Your Honor, he did not. At the point he dispatched the drone, all he knew was that an anonymous caller had phoned the police department to place an anonymous tip.
That would be, would you agree that if it were opposite, where he got the call that she was unconscious based on something that happened in the backyard, that there would be an imminent danger?
Yes, Your Honor. We would concede that if he had that knowledge, then he would have sufficient reasonable suspicion to dispatch the drone.
Well, it could be an imminent danger to find out if any other students were subjected to this.
Yes, Your Honor, in compliance with Exception 4C. Secondly, the attainment of the footage was not in accordance with the plain view doctrine, violating the respondent's expectation of privacy in Section 3B of the Florida statute. And thirdly, the attainment of the footage does not fall under any exception listed in Florida Statute 934.50 because an anonymous tip, in and of itself, is not enough to amount to reasonable suspicion.
But he did give, I mean, the anonymous tip is true, but there was specificity. There were the names of the participants, where it was. One of the more, so there was a lot of detail, was there not, in the anonymous tip?
Yes, Your Honor. The tip was highly detailed. However, as established in Alabama v. White, an anonymous tip, no matter how detailed, in and of itself, is not enough to amount to reasonable suspicion.
But, and how about that Sergeant Johnson, how long had he worked as a police officer on campus, or that was his duties to be a police officer on the campus as opposed to generally in the city?
Yes, Your Honor. As opposing counsel attempted to assert, Sergeant Johnson did have experience as a campus police officer and did decades ago had prior involvement with the DOD.
Let's forget the decades ago, but as a police officer and knowing, having a history of what happens at fraternities, and this being, when did this happen, the beginning of the year?
Yes, Your Honor.
So that pledging goes on and hazing goes on. Why wouldn't that just completely align with his experience as a police officer, that this was something that could be dangerous and that was consistent with his own experience?
Your Honor, the record is silent as to the extent of Sergeant Johnson's knowledge when it came to pledging and hazing and the dangers that it had on campus. And as established in Chiuchi v. Illinois, it's the state's burden in order to compile a complete and accurate record. And because we do not have that information, we are not in a position to assume that Sergeant Johnson had the knowledge necessary in order to amount to reasonable suspicion. Now, the attainment of the footage was not in accordance with the plain view doctrine. Section 3B of the Florida statute prohibits use of a drone in violation of an individual's expectation of privacy. As Justice Periante mentioned, while it has been established through California v. Cirolo that aerial imaging can be used to obtain a warrant to search, that case is distinctly different from the one at hand. The private plane used by the officers in California v. Cirolo did not enhance the officer's ordinary senses. According to the record, page 25, first full paragraph, it was the specific zoom feature, utilized remotely on the drone, that allowed Sergeant Johnson to obtain the evidence he needed to arrest the respondent. Therefore, according to the second requirement of the plain view doctrine, refined by the court in Kelo, the tools enhanced the officer's senses and therefore violated the plain view doctrine. Additionally, the record is silent as to the altitude in which the drone flew. So according to New Mexico v. Davis, we are unsure as to whether or not the drone interfered with the quality of life. The attainment of the footage also does not fall under any exception listed in Florida Statute 934.50 because Sergeant Johnson had no reasonable suspicion that danger was imminent. It's important to recognize that yes, Florida Statute 934.50 provides exceptions to the strict rule against use of drones by law enforcement. Most applicable...
Before you go much further, did you say the officer did or did not know that there had been a death at this house earlier?
The death that had occurred at the house happened after the drone was dispatched to the DoD house. Now, most applicable, but still not accurate in this case, is exception 4C, that a drone may be used if an officer has a reasonable suspicion danger is imminent. The key term is reasonable suspicion. As established in Alabama v. White, Florida v. JL, and State v. RAB, an anonymous tip in and of itself is not enough to amount to reasonable suspicion. Sergeant Johnson, as opposing counsel conceded, did no independent police work to corroborate what was said in this anonymous phone call.
Well, at what point did he come to the house?
Your Honor, Sergeant Johnson dispatched the drone after learning from dispatch that an anonymous call had been placed.
But had he been at the house prior to dispatching the drone?
No, Your Honor.
I'm sorry.
No, Your Honor. He arrived at the house after he dispatched the drone. Therefore,
because when he got there, there was nothing suspicious, and frankly, I'm still sort of wondering how your client got convicted of manslaughter, since it was established that she had an allergic reaction, but that's for another day. But so without the drone footage, he would have not known anything improper was going on.
Precisely, Your Honor. After he conducted an initial investigation at the house, he concluded that no criminal conduct occurred. It was only after he was prompted by the results of the autopsy that he reviewed the drone footage and changed his conclusion that criminal conduct had occurred.
Now, I know you are relying on the Florida statute, but the United States Supreme Court case, which affirmed our case of Florida versus Jardines, are you familiar with that case?
No,
That had the dog sniff on the cartilage? Okay. So why isn't it just as a matter of Fourth Amendment law that since the cartilage is protected, that police officers without reasonable suspicion cannot use something that they could not obtain through their own senses? And so just like the dog sniff in that case, just like Kylo, that this is prohibited regardless of the Florida statute.
Yes, Your Honor. Due to the fact that Sergeant Johnson enhanced his natural senses, he obtained evidence he would not have been able to otherwise without physical intrusion. The issue that we're addressing today when it comes to the Florida statute is in regards to whether or not an exception is applicable. And we submit that this exception is not applicable due to the fact he did no independent police work to corroborate what was said in this anonymous phone call. Chief Justice Kennedy stated that anonymity allows individuals to lie with impunity. Not only was this phone call from an anonymous caller and not a confidential informant, we have no level of verifiable credibility from this caller, and therefore Sergeant Johnson did not have reasonable suspicion. Opposing counsel also mentioned Justice Thomas's acknowledgement of emergency circumstances in the case Navarrete v. California. That case provides a lower standard of corroboration as opposed to Florida v. JL. While Sergeant Johnson did not meet the level of corroboration necessary as established in Florida v. JL, he also did not meet the lower standard established in Navarrete v. California because he did not corroborate any aspect of this anonymous phone call before sending out the drone. For the aforementioned reasons, we ask this court to uphold the decision of the 6th District Court of Appeal and issue a judgment in favor of the respondent, Mr. Wilson, and exclude the evidence collected by the drone as its usage was in violation of Florida Statute 934.50.
Mr. Chief Justice, and may it please the Court, we are happy to concede that the respondent is afforded Fourth Amendment protections to privacy just as every other American is. Just like every other American, however, the respondent is subject to the tests of privacy set about in CATS, even in a curtilage area. Justice Stewart wrote in Katz that what a person knowingly exposes to the public, even in his own home, is not subject to a Fourth Amendment protection. When this case is compared to State v. Rickard, which the opposing counsel invokes, the two primary questions that must be asked are, was it known that people could view the area in question, and did people in fact view the area in question prior to intervention by law enforcement? In Rickard, the answer to both of those questions was no, but in today's case, the answer to both of those questions was yes. And that is so even if the hill is deemed to be private property, because the respondent was aware of these viewings. And the record does not...
Now, okay, so that now we have, your opposing counsel says that the record does not establish that he was aware of the viewings. Are you contesting that fact that's readily ascertainable?
We are, Justice Pariente. It is a falsification of the record to state that it only goes to say that it was known to some that the Hill provided these viewings. It treats this knowledge as public information, and for that reason, we would argue that the defendant lacks an expectation of privacy. And considering the anonymous tip, anonymity may have allowed individuals to lie with impunity.
So if the record doesn't simply say it was known to some, does it say it was known to the respondent?
Justice Lawson, it states that it was known, and in this suggestion, we argue that it treats it as public knowledge, and we think that the respondent, especially as an occupant of the home, would be especially aware of this type of information. And to briefly consider the anonymous tip, anonymity may have allowed individuals to lie with impunity, but Justice Kennedy's opinion in that case of Florida v. JL, as our opposing counsel mentioned, is 17 years old. And Justice Thomas rebutted that argument in his 2014 majority opinion of Navarrete v. California, writing that a reasonable officer could conclude that a false tipster would think twice before using the 911 system, which has several technological features that safeguard against making false reports with immunity. Thomas concludes that behavior alleged by an anonymous tip viewed from the standpoint of an objectionably reasonable officer amounts to reasonable suspicion, even without the corroboration that the opposing counsel alleges is absolutely necessary.
Are you suggesting that JL's been overruled by the U.S. Supreme Court?
Well, Justice Lewis, I see I'm out of time. Justice LaBarga, if I may briefly answer this question, conclude. Justice Lewis, Florida v. JL has not been overruled. We would instead argue that it has been qualified through the case of Navarrete v. California.
How so? I mean, what you just said is that the U.S. Supreme Court, Justice Thomas, has now said that the 911 calls, which was what came in JL, bear a sufficient touch of authenticity to allow unknown calls to come in and be used as probable cause.
Justice Lewis, the case of Navarrete allows for these circumstances to be applicable in cases where serious harm is a factor at play. And although that was not the case in Florida v. JL, we would argue that it was so today, as
But the kid had a gun in JL in his backpack. Are you suggesting that's not dangerous?
The threat of serious harm in this case, we would argue, was much more present through the anonymous tip that was there. And again, the qualification that was made by Thomas in Navarrete gives the determination of the reasonable harm to the police officer to determine whether or not the anonymous tip alleges that, and use that through the police officer's own determination to determine whether or not there was reasonable suspicion. And it is for those reasons that we would ask this court to reverse the decision of the 6th District Court of Appeal. Thank you.
Thank you for your arguments. We're in recess.
All rise.